Hello, everyone, and thank you for joining us. My name is Amanda Kramer, and I am the Alumni Engagement Program Manager at the University of Colorado Boulder's Lead School of Business. Welcome back to our 6th COVID-19 webinar series. These continue to be trying times, and here at CU Boulder, we have gathered our world-renowned faculty and alumni to provide frank and timely insights for life during the COVID-19 pandemic. Today is the first of 6 webinars in this COVID-19 related webinar series. To view upcoming webinars, please visit our website at colorado.edu/business/alumni. Click the drop-down arrow and click Attend Online Webinars. For today's webinar, we're excited to welcome Professor of Law and Public Policy at the University of Connecticut and visiting Distinguished Faculty Fellow at the Byron R. White Center for the Study of American Constitutional Law at the University of Colorado Law School, Dr. Doug Spencer, here presenting the impact of COVID-19 on voting rights. A few housekeeping items before we begin. First, if you have any questions now or during the presentation that you would like to ask Doug, please send a question through the Q&A interface. We will monitor questions as they are submitted, and Doug will respond to them at the end of the presentation. As a reminder, for optimum audio quality, we do have everyone on mute except for myself and our speaker. If you experience any technical difficulties during the webinar, please notify us through the chat interface, and one of our support specialists will touch base with you. Lastly, a link to access the webinar recording will be sent to registrants tomorrow, along with a survey link from today's presentation. Now, I am excited to introduce today's speaker. Doug Spencer is a professor of law and public policy at the University of Connecticut. During the 2020-2021 academic year, he is visiting Colorado law as Distinguished Faculty Fellow at the Byron R. White Center for the Study of American Constitutional Law. Spencer is an election law scholar whose research addresses the role of prejudice and racial attitudes in Voting Rights Act litigation, the empirical implications of various campaign finance regulations, and the many ways that election rules and political campaigns contribute to growing inequality in America. Spencer has been a professor at the University of Connecticut since 2013. He has taught as a visiting professor at the Yale Law School, 2020, and at the University of Chicago's Harris School of Public Policy, 2018 to 2019. He has also worked as an expert witness in voting rights and campaign finance cases. Professor Spencer holds a PhD in jurisprudence and social policy from the University of California, Berkeley. He also earned a JD at Berkeley Law and a MPP at the Goldman School of Public Policy at UC Berkeley. He graduated magna cum laude from Columbia University in 2004 with a BA in philosophy. Welcome, Doug, and thank you so much for being here. I'm going to hand the webinar controls over to you now.
All right, thank you so much, Amanda. I really appreciate you inviting me here today to talk about this really important topic. I want to thank CU Advancement Office for hosting such a great webinar series and bringing all these perspectives to light to our community. I've learned actually quite a bit from watching a previous series of these webinars through CU Advancement on some of the issues of COVID. And I think this is a really incredible opportunity. And I'm looking forward to hearing from people who are watching today and engaging in a dialogue. I do want to say thank you to Laurel Page and Amanda Kramer, who've been amazing at helping to organize and set this up and make me feel so welcome. As Amanda just mentioned, I'm visiting CU this year. And it's been an incredible time even to join the community during this pandemic, where I haven't had an opportunity to meet people in person very much, but I can still tell that this Buff Nation is a big deal and a very tight-knit community. And so I appreciate you having me here today. I want to talk about voting during this pandemic. And there's been a lot of talk about voting. Obviously, the election's a week away. Supreme Court Justice was just confirmed and sworn in yesterday, adding a conservative bloc now that will be deciding voting disputes that are coming up. And I want to both discuss some of what's been going on in the lead up to this election and then preview what may be coming in the next 3 to 4 weeks as we resolve some disputes about voting rules and about who gets to make those decisions about what those voting rules are and how COVID has had an impact on that. I want to start just with a general commentary and a review about what COVID is and what COVID has been doing to us in our society. Here's a video a figure from the New York Times showing average reported cases by day, and this red line is a 7-day average. And it's clear that we're heading into a third peak, and this third peak looks to be much larger than the prior 2 peaks that we've hit. And it's been a cycle in our lives where we hear things are going up, and then we take precautions and we're able to kind of pull it back down. And those precautions can become kind of onerous. And then we start to open things back up and we're in this rolling wave. We're heading into a big peak for a number of reasons, it seems. I'm not an epidemiologist, but it's clear that this is going to be different and perhaps longer than what we've seen before, and perhaps more fatal. So here's an example. This is not real data. This is simulated data about the number of cases that we might expect as we think about this in the weeks going forward, and what a peak what a peak really means. And for a lot of people, this hopefully is second nature by now to think about what these peaks and these curves are, right? Just want to remind us what the stakes are as we think about millions of people flooding into polling stations around the country in just a few days. A good portion of these cases will require hospitalization. Not everybody, but there are people, particularly those in vulnerable populations, who will need hospital care in order to survive the COVID, the disease from the coronavirus. So I just want to focus in really quickly on these hospitalization data, these blue lines. We can imagine this is the number of people who will require hospitalizations, let's say in the state of Colorado. And what we know is that our hospitals are finite and there's only a certain number of beds. And so there's a capacity, and what we're worried about is that there is a large number of people that perhaps will get sick from COVID and require hospitalization, and there will be no beds for them. And ultimately what that means is that a very large group of people with a very high risk of death will not be able to be served, and that they could very well die. The probability of people in those kind of red spikes there of dying are much larger than those in the blue area of this figure, and it's preventable, right? And we're seeing this happening now. We've heard about the threat of reaching hospital capacity in some of these other peaks that we've met, but this peak seems to be bigger and larger and longer, and we're going to run up against this. So here's a story from the Salt Lake Tribune in Utah yesterday, that Utah's hospitals are already now reaching their capacity, and they're now developing ration protocols for who's going to be able to receive care. You go to the hospital and you're unable to breathe, or you feel like COVID is overtaking you, and you'll have to fill out a questionnaire and answer some questions about yourself. And depending on your answers, you'll be sent home, or you may be able to receive a bed in their ICU and get some help. And so we need to do all that we can to avoid that. Obviously, the mitigation effects, we've all seen this, are trying to flatten this curve by taking that chunk that's above hospital capacity and pushing it down into the future. Now, what's important to remember, and I think that this point is lost on much of the debate about mitigating this risk of COVID, is that wearing a mask and social distancing will not prevent people from getting this disease, but it can reduce the risk that you get it on any given day. And the longer timeline that we can stretch out, we're not trying to mitigate the number of people who get cases. We're trying to mitigate when those people get their cases, so that we're able to treat them, so that we're not losing people. And so we push ourselves closer and closer and closer to when a vaccine is ready that can eliminate the disease. So as we enter into these thoughts about mitigating and what we can do as policymakers, but we obviously in our individual lives, wearing a mask and social distancing has been told to us by our scientific advisors in the CDC, will help to mitigate that socially and in our lives. But as public policymakers, how do we think about crafting solutions to what's happening in our lives in a way that can elongate the time frame in which people in our society will get COVID? Not necessarily the number, just the time frame which will allow us to care for these people and hopefully get a vaccine. I raise this because voting is one of these public policies that policymakers need to be thinking about when they're developing a protocol to avoid an outbreak of COVID. So here's this idea dynamically of flattening the curve. We're just trying to take a peak of people who are about to get sick Between now and in February, the predictions is that we're going to lose in actual deaths the same number of people that we've lost already over the entire course of the pandemic over the last 11 months. And we want to push those out into the future. That's really the goal. And ideally, you can see that healthcare capacity would also increase, but we haven't done a really good job at increasing hospital beds, maybe as much as we should have. This is the idea. How does voting play into this? Well, one, coronavirus and the government's response to coronavirus has actually motivated a lot of voters who either really agree with or disagree with the candidates running for office and their views and their record on how to handle this pandemic. So one reason why COVID is impacting elections and voting rights is that it's motivating an issue area. People feel like President Trump has not done enough. Now they're motivated to go out and vote for Joe Biden. People feel maybe like President Trump did exactly the right things and the Democrats don't know what they're doing. They're motivated to get out and get Trump a second term and down the ballot through to our Senate race here in Colorado and to other ballots. So it's on people's mind. It's become maybe the most predominant issue that this election will be decided on, but there's also some practical implications. So as I mentioned before, we know from the CDC and from local public health officials that the best way to prevent illness is to avoid being exposed to the virus. So this involves wearing a mask to prevent spreading to others and staying far away from people. And that's not really the way that our elections are run. We don't run our elections in a socially distanced manner. And we are not used to wearing masks and gloves and sanitizer in a voting area. It's actually a very social experience. You talk to the poll worker and you visit with your neighbor and you use the same voting booth and you touch the same scanner. And oftentimes you're crammed into a little hallway of some building in your neighborhood or a garage. If you're lucky, you might be in a gymnasium in a school, but frankly, if you're in a gymnasium in a school, there might be 3 or 4 precincts there and there may be, several hundred people milling about. So how can we go about arranging this democratic act in the midst of this pandemic? Well, it may not surprise you, since I presume people are following the news, that most states now provide some opportunity for voters to mail in their ballots. Now, we're lucky in Colorado because not only are we able to mail our ballots in, but our state's been doing this for a long time, so they know what they're doing. So our system's going to run well. You apply for your ballot and you get an email that tells you your ballot's being tracked and it'll be delivered in 3 days and we received it and it's counted on time and it's taken care of and there's not a lack of communication, and by and large we're doing this really well. And some other states who have a long history of this, Washington, Oregon, Utah, also have good track records. Some states have adopted mail-in voting for the first time this year. That's a miraculous opportunity for people who may not want to go and vote in person to still have their voice heard. But there are going to be some problems, and those problems may spill into the courts. Obviously, the rhetoric is out there that this is chaos or rigged or fraud, but I want to talk about how these issues may spill into court specifically and what the law is about them. Before we move on, though, I do want to point out there are these 7 orange states here. And this map actually is little blocks. They're not counties. They're blocks of populations of 100,000 people. So you can kind of get a little bit better sense of the population balance. But there are 7 states that do provide for absentee balloting, but only in a very restricted sense. In fact, even related to COVID, you have to prove that you are suffering from COVID at the time when you request your absentee ballot. You cannot request it for fear of getting it or because you're caring for somebody who has it. It has to be very specific. Texas will allow you to get an absentee ballot if you're 65 years or older, so that's one exception. But by and large, in these orange states, the predominant method of voting will be in person. And frankly, in every state, people will still be showing up to the polls to vote. One more look kind of at the politics of these states really quickly before we move on. You can see that the states that are more likely to see people or require people to show up and vote in person right now are ranked as either solid Republican states or likely Republican states, whereas most of the states that have an all mail-in ballot system are solidly Democratic or likely Democratic in terms of their statewide polling for the presidential race. And there are exceptions. Obviously, New York is an in-person voting state that's likely to be Democratic, and Utah's a Republican state that has mail-in voting. But there will be some partisan effects in terms of how the voting rules affect people. And so I think that makes courts all the more important in providing a neutral third-party referee for some of these disputes, even though a lot of the plaintiffs are going to be from one party and the defendants will be from another party, even though some of these disputes will benefit voters in a particular party more than others, because there is this split underlying them. But the legal issues should be neutral with regard to all of these issues. All right. Tens of millions of people, despite all of these changes and all of these accommodations that we've been trying to make in our states, tens of millions of people are still going to vote in person for a number of reasons. One, they live in one of these 7 states where that's really their only option. Two, what we've seen from survey data is that Republicans have become skeptical of voting by mail, in large part because of rhetoric from President Trump, but also from other Republican leaders that maybe it's not the safest way to cast a ballot, that it could be rejected for one reason or another. And so there's Republicans who are motivated to show up in person because of fear of an inadequate mail-in process. And Democrats are being motivated to vote in person because they are afraid of some chaos or slow vote count after the election's over next Tuesday, that it will take a few days to actually count all the Democratic ballots. And they're worried that if there's a wave, a blue shift it's been called, but a wave of Democratic votes after the election, so that while it looks like Republican candidates are earning more votes early on, that they're overwhelmed by these later votes, that could be a recipe for some candidates, and obviously most importantly President Trump, because he's shown a predilection for this, to talk about fraud or shenanigans of some kind. And fearful of that outcome, there's been a wave of mobilization in Democratic constituencies to show up and vote in person. So there still will likely be tens of millions, maybe more than tens of millions. We may get to 100 million people who vote in person this year, who will show up and may put themselves at risk. And so what we've seen from this already, people who are forced to vote in person, is people showing up to the polling stations in hazmat suits. Here's a voter, in Wisconsin during the primary election this past spring, who's immunocompromised in the top right of the slide. And she got a garbage bag and some cleaning gloves and some duct tape. And she basically fashioned herself a hazmat suit because she did not want to give up her right to vote, but she recognized that exercising her voice in politics may pose fatal to her, and she still came anyway. There were voters standing in line for several blocks in Milwaukee here on the bottom left, and no poll workers showed up in Milwaukee. So they, instead of, I can't remember exactly, there were something like 175 polling stations that normally operate in Milwaukee, and they were down to five polling stations during the pandemic early on in the primary, because poll workers who skewed older and more vulnerable were not showing up to man those polling stations, and that affected people's voting rights. Here's a map from my own research. This is research that I've done with a team actually of experts, some statisticians, public health experts, and some lawyers. And what we're interested in is finding populations in the country who are the most vulnerable to COVID, who have the underlying conditions of diabetes and pulmonary disease, and who have social conditions, including poverty and frontline workers, people who aren't able to work from home and stay socially distanced. And this is data we've collected from public health data sets, from public opinion surveys about people who report their own work circumstances. And we were able to rank every single county in the country in terms of how vulnerable its population is, which is to say, if COVID were to reach this population, then the fatality rate in that population would be very, very high, because it wouldn't just pass through the population or make people mildly sick, but it would hit these particular populations very, very severely. And we've ranked all 3,200 counties according to how dire and how risky it is for COVID in those counties in an outbreak. And then we've color coded those counties. This is the top, essentially people are in the top 10% of the counties. And we've color coded them by the voting rules that exist in their counties. So these red counties are states or counties where voters will be required to show up in person to vote, even though they live in a community that's extraordinarily vulnerable for mortality or death from COVID-19. And so there's some geographic, you can see a little bit of this is focused in the South, but there's kind of geographic dispersion around the country, which is to say that the reforms and the accommodations we've made have really not been enough, or at least they haven't been targeted in the right ways. There's been general senses about voter fraud, access to the ballot, voting rights generally, but there hasn't been a very careful attention paid by our lawmakers to the franchise, the right to vote, and its interaction with vulnerability for COVID. And the reason why that's so important is that the people who are vulnerable to have their voting rights taken away for whatever reason are the same kind of communities who are vulnerable for COVID. We see this over and over in all kinds of public policy, the compounded effects of vulnerable communities. And it's no different that vulnerable voters are going to be running headlong right into people who are vulnerable for COVID. And there could be a recipe for disaster right as we're getting into this huge peak, the biggest peak we've had of COVID cases. We're now going to be sending out 100 million people to interact with each other on the same day in enclosed spaces, and could turn an election in the United States, which is the world's greatest democratic act on any day of any year, into a super spreader event for this disease. And that's really unfortunate. And it shows a little bit of a lack of foresight, and it shows perhaps a little bit too much polarization and partisanship in terms of the policymaking around voting. Now, I want to shift and think about voting in the courts. Now, there's a joint project of Stanford and MIT to track all the litigation related to COVID, essentially. This is not just election litigation, this is all of the election litigation related to COVID. Now, that's a lot of it, but not everything is related to COVID. Some of it's about ballot design and regular litigation. But what this team has found is more than 300 cases now in 44 states of just COVID-related litigation. Remember, COVID was only deemed a national emergency on March 12th. And so we're only talking about 6 or 7 or 8 months here, 300 cases in federal and state court. It's an amazing amount of litigation. In fact, here is tracking the number of election-related challenges or election lawsuits that have taken place. You can see a bump after 2000 and Bush versus Gore, where cases doubled. You know, we were seeing about 90 to 100 election law cases per election cycle during the 90s. But after Bush versus Gore, lawyers recognized and candidates recognized that elections could be decided in the courts. And so now the candidates are spending almost as much money arguing their positions to judges as they are arguing their platforms to voters. That doesn't seem like the right outcome either. But there is a silver lining. This is the number of overall election lawsuits. I have a question mark for 2020. It's likely to be close to 1,000. There's 300 just COVID-related cases, and the election hasn't happened. There will be hundreds of cases that come about after the election for one reason or another, and we may get close to 1,000 cases. The silver lining of all this litigation is that much of the disputes have been resolved. So a lot of the issues that we may be worried about and that many people have been worried about, commentators and scholars have been worried about coming to bear next week or in 2 weeks from now, a lot of those issues have already been resolved. And so courts now, after the election, can just cite to these cases that have been coming out in the summer. And so I think that's one of the silver linings. And what have we been able to figure out? Well, 3 different themes have been running through the cases that have come, the hundreds of cases that we've heard so far, and that we are likely to see in the next few weeks. In none of these is public health the theme. Now, in large part, that's because courts generally defer to policymakers to balance all of the different interests of the public safety and the public health, and then the public's need for services and voting rights or whatever it may be. And so we have not seen courts step in and decide that a population has vulnerability in terms of health. What we do is we see courts stepping in if they see vulnerability related to voting rights because it's a fundamental right in the Constitution. And the arguments that we see that have been debated by judges are, one, related to voter fraud, something called the Purcell principle, and then this idea about the role of state legislatures. And I want to walk through each of these just for a few minutes to give you a sense, particularly for those who don't have a legal training or legal background, what the courts say about these issues and what it could portend for future challenges. All right, voter fraud. Voter fraud is an argument that's made usually if a state legislature has expanded the right to vote. So the argument is a state legislature looks at its community and says, my community is vulnerable. I'm going to extend the right to vote by allowing for mail-in voting, by accepting absentee ballots for 3 days after the election, as long as they're postmarked before the election, allowing early voting. And the reaction to that expansion of the right to vote is, you can't do that because it's going to create a whole bunch of voter fraud. Now, in politics, you can say whatever you want. So a good example on President Trump's Twitter feed is that mail-in ballots are a fraudulent activity just by nature, just by their design. And they'll be illegal, and they'll be forged, and there'll be fraud, and the election will be rigged. You can say whatever you want. And the accountability is whether or not leaders in the party will want to push back against that, or voters want to vote against you because of your beliefs on that issue. That's it. Twitter does not require, if you make a claim, that you add some subtweets that provide evidence, right? But a court does. Courts require you, there's an evidentiary burden. It's not rhetorical when you show up to a judge and you say, I'm making an argument of voter fraud. The judge says, show me the evidence. So here's an example of an exchange from Montana. In Montana, counties were permitted, if they wanted, to mail ballots to their voters. They didn't have to. And the Republican National Committee filed a lawsuit and said that will lead to all kinds of fraud. And at trial, the judge said to the lawyer, a very prominent Republican lawyer actually, do you have any evidence of any voter fraud actually existent in Montana in the last 10 to 20 years? Any fraud that's actual in 10 to 20 years, like a huge window. And the lawyer said no. He says, it's irrelevant. It's so small. There's no evidence. Well, then it's not a surprise that that judge ultimately ruled against the Republican National Committee in that case, and said it's fine for the state of Montana to do this. If your complaint is that it's going to lead to fraud, well, that's a fiction. If you have another complaint, then bring me a different case. But if your complaint is about voter fraud, we're dismissing the case. Dozens and dozens of courts have done this all over the country. And to the extent that you think that the judiciary in America is politicized, then it's perhaps worth noting that judges who have been appointed by George W. Bush and Donald Trump and Obama and Clinton and going back have all said there's no evidence of voter fraud to justify these legal challenges. And so states who have made attempts at expanding their franchise, expanding their opportunities to vote, given COVID or other reasons, have been able to do that because almost all of the challenges have been about voter fraud, and courts have said there's no evidence of that. When you're forced to show the evidence, you're unable to, therefore the challenges are dismissed. Here the judge called it fiction. Other judges are just dismissing these cases in the dozens. So voter fraud is maybe a winning argument on Twitter, and it may be a winning argument at a debate for a political office. It's not going to be a winning argument in court. This is never proven to be a winning argument in court, and it will not be going forward. The second issue that's come up is this idea of the Purcell principle. Now, Purcell is just the name of a case. It's actually a case from the Ninth Circuit in California in the 90s, Purcell versus Gonzalez. But there's an idea that was articulated in that case that said courts should be very hesitant if changes are made at the last second of getting involved, or courts shouldn't facilitate the changing of election rules as the election draws near, because there's a risk that voters will be confused. And judges shouldn't be confusing voters. And so judges need to favor the status quo. Whatever exists that voters know about, we need to put our thumb on the scales in favor of that. And we can postpone the dispute, and after the election's over, we'll take the case up again, and then we can resolve it. But we're just going to let the status quo hold for now, because we don't want to disenfranchise voters. We don't want to change the deadline at the last minute, and then voters who thought their ballot would count doesn't, and then they lose hope in the system. That's the idea. That's the Purcell principle. So in theory, courts don't want to confuse voters. And also courts don't want to be pawns in political posturing and strategy. Sometimes legislators or party officials wait until an election gets close and they try to change the rules. And they're like, well, we'll go to court, or they try to file a lawsuit, but they don't file it early on to get certainty. They file it at the last minute, maybe specifically so they can create confusion. And courts don't want to play that game. They don't want to be used in that way. And so by and large, this idea is that courts should avoid either making changes or upholding changes at the last minute, in the last few weeks or months before an election. That's the theory. In practice, it hasn't looked so clean. In practice, this Purcell principle has become another political tool of judges to get outcomes that look more political than legal. And here's some of the ways that they do that. They say, well, I'm going to apply the Purcell principle, which requires me to favor the status quo. Okay, well, what's the status quo? Is the status quo the voting rules that existed last January when the world was kind of operating under the normal circumstances? Or is the status quo the fact that in July, people are hospitalized and afraid to go outside and voting in person terrifies people? What are we going to use as our baseline? And if we're responding to COVID because it's changed our lives and we're responding in July or August, even though that's within a few months of an election, is the baseline that we're changing from all the way back in January, or do we recognize we're living in unstable times and we're creating more stability? And that's a really difficult question, and there has been no consistency in the courts about this. Some judges have said, you know, we really need to just look at the voting rules that existed last year, and any changes from those at this point are unacceptable, meaning that some voting rules that would allow vulnerable people to vote, vulnerable populations to vote because of COVID, don't get that chance because it feels like the legislature might be changing things too close to the election. And on the other hand, you may say, well, COVID's shaken everything up. What we're really doing is this change is actually putting people back to the status quo. This is actually making people better because it's going to allow people to vote in a more robust way. So the judges who have been arguing this are coming up with different inputs. They're interpreting what the baseline is in different ways. And unlike the voter fraud cases where judges appointed by Democrats and judges appointed by Republicans have come to the same conclusion, when it comes to the Purcell principle, and this goes all the way up to the US Supreme Court, where the Republican appointees and the Democratic appointees have butted heads about this, and the Republican appointees who have a majority, so they're often writing the majority opinions here, they're invoking the Purcell principle to strike down changes that would make voting easier. But then when states have tried to make things easier, they're pulling that back and saying, well, it's too close to an election. And so it's created some cynicism around this principle that's been in play for more than a decade. So that's a second theme that's come up in these cases. It's not really a legal doctrine so much as it is a principle that the Supreme Court has articulated for itself and tries to follow, but it's become highly politicized. The last issue is the most important issue, and it's about the role of state legislatures. And here we're going to get a little bit kind of more technical on the legal side. The argument about who gets to decide what an election looks like is a debate about language from the US Constitution. And this is a debate usually when the state legislature has not protected voting rights. And so if the state legislature has not protected voting rights, somebody else might have stepped in and protected voting rights. Maybe a judge interpreted a state statute and said, that statute is too strict. Our state constitution guarantees that every election shall be open and free and fair. More than half of the state constitutions have a provision like that in their state constitution. And the state Supreme Court might say, we don't interpret a state law that requires absentee ballots to be rejected if they arrive after election day, even if they were mailed beforehand because the post office is dysfunctional. We don't think that that is a fair process. And so we're going to allow absentee ballots to be counted 3 or 4 days after the election, as long as they're postmarked before the election. This is the kind of dispute. The legislature has not protected voting rights and somebody else has, often a judge. And in that case, the debate is judges don't get to make those rules. Those rules have to be made by the legislature. Where is that idea coming from? Well, that idea is coming from the US Constitution itself in 2 different provisions, specifically in this case. The word legislature appears more than a dozen times in the US Constitution, but I'm just focused on these 2 areas that are related to voting. Article 1, Section 4 says the times, places, and manner of holding elections for senators and representatives, meaning federal elections, shall be prescribed in each state by the legislature thereof. Doesn't say anything about the state Supreme Court or a federal court. What about the Electoral College? What about the rules for appointing members of the Electoral College, which right now they're appointed based on whoever wins the vote in a particular state? Article 2 says each state shall appoint in such manner as the legislature thereof may direct a number of electors to the Electoral College, equal to the whole number of senators and representatives in that state. Again, the word legislature appears by itself. So this argument says if we look at Article 1, Section 4, Article 2, Section 1, we see that the legislature gets to make these choices. So if a court passes a law and changes the rules relative to what the legislature wants, these provisions in the Constitution say that courts may not do that. And this is a debate that's at the core of most of the hot button litigation issues right now, including a case that was decided last night at 8 o'clock. So there's some like hot off the presses slides here in a minute that I added just at the last minute to incorporate that. Coming from these two provisions or questions, well, does the legislature then get to act unilaterally? They just get to do whatever they want, no matter what? And are their rules subject to judicial review? Not only does the process as they get to do it by themselves, but in the end, are they restricted by what their state constitution says or not? Well, on that first question, we actually have a pretty good answer from cases going back almost 100 years. In Smiley versus Holm, the Supreme Court held that the governor has a role to play. So even though it says the legislature gets to decide how to run elections and the legislature gets to decide how to appoint electors, whatever those rules are, the legislature decides. If the governor vetoes that, then it doesn't exist, or the legislature has to override their veto with 2/3 vote or something. And the legislature in 1932, a state legislature, said that's not fair because the Constitution says the legislature gets to decide, not the governor. And the Supreme Court said, yeah, but the governor is part of the legislative process. 1916, legislature passes a law about redistricting. And afterwards, there's a popular referendum on the ballot that overturns the legislative act. And the legislature files a lawsuit. It says, again, the Constitution's clear. The word legislature appears there. And the Supreme Court said, look, the power of politics in America belong to the people. And so if the people override the legislature, even though the word legislature appears in the Constitution, that's an acceptable act of power. And so legislatures are constrained not only by gubernatorial vetoes, but also by popular referenda. Those are old cases. So you may say, well, whatever, what do people know in 1916? Well, in 2014, the Roberts Court decided a case on this exact issue. In Arizona, on a ballot initiative, voters created an independent redistricting commission. And that independent redistricting commission drew new lines for state legislative districts. And the state legislature was upset about that. You can see in the name of the case here, Arizona State Legislature versus Arizona Independent Redistricting Commission. The legislature filed a lawsuit and they said the Independent Redistricting Commission has no authority because if you look at Article 1 and Article 2 in the US Constitution, it says the legislature gets to decide all of these disputes, how the time and manner and places of running an election. And the Supreme Court said, no, look at Smiley versus Holm, look at Davis versus Hildebrand. We interpret the word legislature to mean the legislative process in a state. And that includes the gubernatorial veto, and that includes the popular ballot process, the ballot initiatives for making rules related to voting. Now, there's one area that, so the answer to whether a legislature can act unilaterally is no. The legislative process itself needs to take place. But what happens after the legislative process has taken place and everyone's on the same page, the law gets passed and it exists? What about a judge? Can a legislature pass a law that violates the state's constitution or not? And here the results are actually a little bit more confusing. It's not so clear the answer is no. In fact, the answer may be that a legislature can violate the state constitution. Now, here we get cases that are quite recent. This was one of the issues that was being debated among justices in Bush versus Gore. It's not an issue on which the case was decided. It only, no position on this issue garnered enough votes, a majority of votes, 5 votes on the Supreme Court. But there were 3 justices in Bush versus Gore who said a state Supreme Court may not override the state legislature. Bush versus Gore is a long time ago, and we think about it as a case where the Supreme Court ruled in a way that awarded George W. Bush the presidency, or maybe if you look under the hood a little bit, you'll realize it was about the recount in Florida. But what the legal issue was whether the state Supreme Court in Florida, which had ordered a recount of all the ballots, had authority to make that decision when the state legislature had said, we're not going to order a recount of ballots. And so it was really refereeing a dispute between the state Supreme Court and the state legislature. Now, the Supreme Court ultimately wasn't able to figure out an answer to that question. 3 justices said the Supreme Court can't make that rule, and 4 justices said they could, but the decision was decided on other grounds. But this debate was sitting there in the court. Last week, the Supreme Court reviewed a decision from the Pennsylvania State Supreme Court, which had interpreted a state statute that required absentee ballots to be counted in a fair and open way. And the state legislature said, that means they have to be received on election day. And the state Supreme Court said, well, actually, that means that they can be received up to 3 days after the election. That's how we interpret the state constitution. And we understand the state legislature's rules, but that rule violates our constitutional guarantee of free and fair elections. And the state Supreme Court changed the deadline. And that challenge came to the Supreme Court, and the Supreme Court deadlocked 4-4. And when the Supreme Court ties, what that means is whatever the lower court held now becomes the controlling opinion. So by splitting on that issue, 4 justices said the state Supreme Court cannot do that, just like in Bush versus Gore. And 4 justices said, of course they can do that. Look at Smiley versus Holm, look at Davis versus Hildebrand, look at Arizona State Legislature versus Arizona Independent Redistricting Commission. Obviously the state court can do this. They split, and so the state Supreme Court was upheld. And in Pennsylvania, absentee ballots now will be accepted as long as they're received 3 days after the election and were postmarked before the election. Yesterday, a very similar issue came to the Supreme Court, not out of Pennsylvania, but out of Wisconsin. Again, the legislature had said the absentee ballots needed to be received on election day. And then a federal judge, not the state Supreme Court, but a federal judge had said that violates people's voting rights, their fundamental right under the federal constitution. And so a federal judge had ordered absentee ballots to be accepted for a few days after the election. And that case overturned the federal judge's rule. So now absentee ballots in Wisconsin have to be received on election day. But we see some tea leaves on this issue about the role of courts in making those decisions. Justice Kavanaugh said the legislature has the final say no matter what. And he actually cites to Bush versus Gore. He's the first justice, or the second justice to ever cite to Bush versus Gore in its 20-year history. And that makes sense because if you remember, the Supreme Court in Bush versus Gore said, don't ever cite to this case because it's a one-off. Elena Kagan said the legislature follows the regular lawmaking process, and Justice Roberts said we should have different rules for federal courts and state Supreme Courts. All right, one final thought, and then I'll be quiet because I do want to get to the Q&A. And I know we have about 15 or 20 more minutes. The elections in the United States are incredibly unequal. And in fact, political inequality, I think, is one of the biggest challenges that we're facing. Not partisan polarization and all this rhetoric about how much we can't talk to each other, but this deep baked in inequality. And this inequality will grow with COVID because of the compounded effects, not only of particularly vulnerable communities not having access to the ballot, but now facing COVID risk and either choosing to protect their health over their right to vote or putting themselves in grave danger to vote. But if we look here at this slide about the gap between the wealthiest 20% of people in our country and the poorest 20% of people in our country, we see a huge gap in voter turnout. And it's not just because of registration. If you look at the percent of people who voted among those who are registered, even if we could register everybody, there's still a gap in who turns out. And the policymakers, as I've been arguing, have not been very good at addressing this issue, at really focusing on the vulnerable communities that they need to. But I also argue that campaigns and parties have a role to play here, and they're failing in that role. Here's a picture of contact by the John Kerry campaign in Ohio in 2004. So on the x-axis from the left, you'll see these are each dot basically is a voter or a person in Ohio, a potential voter, registered voter. On the left are people who are Republican, on the right are people who are Democratic, and then you look at the y-axis and you see at the top are people who are unlikely to vote, and as you go down to the bottom, we get into high turnout, people who are quite likely to vote. And green means the Kerry campaign contacted them a lot, and red means they never contacted them. So you can see that the John Kerry campaign basically only talked to Democratic voters. They tried to turn them out to vote. One of the miraculous things that the Obama campaign did was they were able to use data and what's been called micro-targeting, is to look, who do we think is going to turn out to vote and who do we think is a Democrat or Republican, and let's go target those individuals. And you can see a much richer and kind of more rational approach to their politics. What's happened since then is no campaign contacts people who are unlikely to turn out, which means they're not on the voter rolls as having turned out before. And this is going to be a big issue, residual effect of this election. Absentee ballots are being rejected, not at a huge rate, 1%, maybe less than 1%, not enough to call into question the legitimacy of the election, but the rate of rejection is much higher for poor voters, much higher for Black and brown voters. And what that means is that even if those voters turned out, their ballots rejected, they won't show up as having voted, and they'll end up in this red category. They'll end up looking to campaigns like they don't like to vote. And campaigns will never reach out to them, will never sell their message to them, will never mobilize them to vote. And so the cycle then, even if it had been broken by somebody mailing an absentee ballot, by having it rejected, will become part of this cycle and will breed inequality going forward. And COVID, I think, has only exacerbated that. All right, that was kind of a one final point, but I'll end there and really look forward to answering some questions from those of you who are still watching.
Great, thank you, Doug. We will move into our Q&A portion of the presentation now. If you have a question for Doug, please submit it through the Q&A interface. We're going to start with a question here from Dwight, who asks, why isn't voting for federal offices regulated by federal law instead of state law? Why isn't voting by mail always an option?
This is a really great question, Dwight. In fact, that language in Article 1, Section 4 says the state legislatures get to decide the time and manner and place of holding elections, but Congress can intervene and overturn that if they want. And so Congress has created some rules for federal elections, and it's possible that states could have different rules for elections that only feature candidates for state office, and then they follow the federal rules for the elections for federal office. Partially because that's confusing, partially because those elections, sometimes you have a federal candidate because it's a special election. And it's hard to keep everything straight, and a lack of money really to develop different ballots. In almost every case, states have just adopted whatever the federal reforms are so they can run a uniform election process. Congress would have final say. Congress could pass a law that makes voting by mail mandatory or permissible for every election that features a federal candidate. And then we would see maybe some more uniformity among the states. Right now, Congress really only has stepped in a few ways. You know, they dictate the day the election happens, the first Tuesday after the first Monday in November, for example. And they've dictated a few other rules about, you know, you can't bribe, you can't pay people for their vote. In some state elections, you can. It's not, you know, like it's against the law, for example, to give people donuts at the polls if they vote under federal law. You can't really pay people to vote. Some state laws permit that. So there are some differences. But by and large, the federal regulations are small, and everything's been delegated to states, which is why we see a patchwork of these different rules. It could become federalized. It just has not been.
Thank you for that. And this is a question that stems from that. This is from Lauren, who asks, what is the best resource for voters to find out what the laws are in our state around voting?
So our Secretary of State, Jenna Griswold, does a fine job of keeping those regulations up and in the public. And so if you go to the Secretary of State's website, all of the rules are listed. I think it's a very user-friendly website. Outside of our own rules, I would encourage people to look at what's called the National Conference on State Legislatures, ncsl.org. There you can see not only Colorado's provisions for mail-in voting, windows of early voting, deadlines for ballot certification, rules on voter ID. You can see those laid out, but you see them in a table with all 50 states on all of those issues. I find that to be really helpful because I do want to know what the rules are for me so I can get my ballot in, but I also like to get a sense of, in this mosaic, whether I'm living in a place that believes that my right to vote should be protected and celebrated, or whether I'm going to have to jump through more hoops. And so that's ncsl.org is another resource I would highly recommend.
Okay, great. Thank you for that helpful information. Our next question comes from Virginia, who asks, what should a new VRA look like in light of the 2013 evisceration of Section 5? This is
a really, really important question for voting rights and civil rights activists and lawyers. The Voting Rights Act, the VRA that Virginia references, was challenged in 2013 in the Supreme Court in a case called Shelby County versus Holder. And in that case, the Supreme Court had eviscerated a very powerful provision. So in certain parts of our country, primarily in the Deep South, there had been a 100-year history of discrimination against voters of color. Even though the 15th Amendment, which was ratified in 1870, says you can't discriminate in voting based on the color of people's skin. And creative policymakers had found ways to do that. They said, well, you have to read, but they only applied a literacy test to Black voters. Or you had to jump through hoops that were only applied to particular communities. And in 1965, the Voting Rights Act was passed, and it said, in these particular states, which have just failed to stop discrimination, those states have to get permission from a judge or from the federal government before they can change their election rules. Basically, the federal government will give you a blessing that what you're doing is not racist. And in 2013, the Supreme Court eliminated that rule. And so now states all over the country can make changes however they want, and none of them need to prove that they're not doing something that's nefarious before they make those changes. And that's had a big impact on voting rights. In fact, I think that it's hindered a lot of voting rights for minority communities in the South. What can be done? Well, Congress has the ability to pass a new Voting Rights Act, and the Voting Rights Act was actually passed by the House of Representatives. It wasn't taken up by the Senate. I think politics will have a big say in this. I don't think the Voting Rights Act is a partisan bill. If you see who authorized and supported and signed the bill, it's been supported by bipartisan coalitions of Republicans and Democrats. It was reauthorized in 1982, signed by Ronald Reagan. It was reauthorized in 2006 and signed by George W. Bush. And so there's been Republican presidents buying in, Republican legislators. This Republican Senate this last year did not take up this issue. But if the Senate were to flip, the Voting Rights Act amendments of 2019 that were passed by the House of Representatives could be passed by the Senate. The Supreme Court's problem with the Voting Rights Act in 2013 was that it continued to punish the South, not because the South is the South, but because it was using data from the 1960s. Congress in the 1960s said, you're going to have to get permission if you fit one of these requirements from the census. And that data was never updated. So one thing that the Congress could do is just update the data, and it would survive a constitutional challenge, even under the Roberts Court. And there was part of that in these VRA amendments of 2019. I think that's one of the more hopeful places, because I don't think that litigation, I don't think that in the courts, minority voters are going to have strong protections from judges the same way that they might be able to get those protections from their elected leaders. And judges will only provide those protections if there's a statutory basis for that. So I think that the best response is for Congress to act. And I was not very hopeful for the last 7 or 8 years. I think that there's a chance that if the Senate were to flip to a Democrat and Biden were to win the election, that the Voting Rights Act amendments of 2019 could pass. And I think there are going to be a lot of things that change that are going to be good or bad or both. I think that the Voting Rights Act amendments of 2019 being implemented would be an unqualified good.
Okay. Thank you so much for that comprehensive answer. And we have another question here related to the Voting Rights Act. This question is from Casey, who asks, do you foresee changes to the Voting Rights Act to provide citizens the ability to vote in a safe and remote manner during times of pandemics or when other health or environmental factors preclude the ability to safely vote in person?
Man, I hate to be a downer, but I don't. I think that we litigate and we legislate on voting rights issues in response to emergencies and controversy. For example, we knew that voting machines were outdated and terrible. We did nothing about it until Bush versus Gore showed us that a bad voting machine can have a big impact. We've known about COVID since March. Some changes have been made, but they're temporary changes in many states and they'll go back. We know that there's a threat of foreign interference. We know that there's a threat of a tornado or a flood, and we don't have protocol in place to handle that. We wait until those things happen and we respond one at a time. Oh, there's been a flood, so maybe in this neighborhood we'll allow them to extend their voting hours for another day. There's never been a systematic attempt to look at pandemics, to look at acts of God or natural disasters and come up with a plan. And it's unfortunate. And I really think the reason is it feeds into this idea of inequality. The people making the decisions are very elite and wealthy. And what they see is opportunities. When a crisis hits, there's an opportunity for them to promote all the reforms that they wanted anyway in these moments that may or may not actually help marginalized communities. Until marginalized communities are able to elect candidates that represent their interests, I don't think we're going to get a very solid response to these natural disasters, in part because the natural disasters usually are impacting marginalized communities, and people who are elite and wealthy and privileged are able to avoid a lot of those consequences. It's a sad truth.
Thank you. Thank you for that. That absolutely makes sense. And taking a look at the time, we're going to move into our final two questions here. The next question is from an anonymous attendee. How do you feel about moving away from the electoral college and allowing the overall popular vote to elect the president?
I think I have mixed feelings about this. I don't think that it's automatically better for a country if there's a popular vote. I think that we're a country that's built up of states, and that requiring some coalition of states, it's a different politics than having everybody elect the president. But it is part of our history. We do have state sovereign governments and organizations, so it's not totally crazy to do that. I do think that as the Senate has remained fixed at 2 senators per state and the state populations have shifted, it's created a hugely undemocratic government, and I think it's bred a lot of our problems. So that worries me, but that's not going to go away if we elect a president by the national popular vote. I do think that it would make a lot of sense for the kind of legitimacy of the person who is involved to have earned the most votes. But there's one kind of trade-off and that people don't appreciate, and I'm not going to make a judgment call on it except for just to put it up there for people to understand. Bush versus Gore was a pretty contentious debate, and it was about a recount in one state. If the election is really close and we're looking at the national popular vote, we have to recount ballots in every single state and every single precinct and every single county to make that decision. And that can lead to, that would be a nightmare scenario. So one of the good things about the Electoral College is it localizes the disputes, even as it localizes the results, which can have, kind of undemocratic response in some ways. So we'd need to figure out a way to glean all of the good things from that. And I think the risk of a nationwide recount is severe enough that it gives me some hesitancy about automatically just saying, let's have the popular vote winner win every time.
Okay, great. Thank you for that. And we'll move into our final question now, a question from Mark, who asks, are the pandemic's effects on the election related or similar in any way to the influence of foreign entities on the election?
I think they're related to the extent that they both involve a lot of misinformation. I think that they're related in that we don't know very much about their true nature. And so it's hard for us to respond in a targeted way and to be sure that we're addressing the problem. Do we know which Facebook posts when you're scrolling through your feed are coming from reliable sources or not? You may, even if you don't want to, be forming opinions based on things that aren't real and things that have been planted. I think COVID's the same way. It's this silent assassin working its way through our country, and it's hard to see where it is and where it's going to get you and how voting may or may not impact it. And so I do think kind of in those kind of more meta ways, there are some similarities. I think the difference is that COVID is hitting marginalized communities in a way that I don't think foreign misinformation is. I think foreign misinformation actually is targeted at party leaders and likely voters and kind of people who are elite in society and trying to create division among those communities, particularly on race or gender inequality, things like that. I think COVID is working its way through marginalized communities who may not be involved in politics at all. And it's basically exposing America's tolerance for suffering of the least among us. And whereas misinformation is basically exposing America's polarization and our inability to be friends with people who disagree with us. That's a fundamentally different thing, and related to free speech and some other fundamental values maybe. Whereas COVID really, I think, is exposing more of a darker side of our social fabric that may not be as tightly woven as we need it to be.
Okay. Great. Well, thank you for that. And thank you so much to everyone for joining us for today's presentation. Thank you. A special thank you to Doug for this great information. At this time, we invite you to provide your feedback on the webinar by answering the following poll question. On a scale from 1 to 10, how likely are you to recommend this webinar to a friend or other CU Boulder alumni? Please take the time to cast your vote right now. We thank you in advance for submitting your feedback. As a reminder, all webinar attendees will receive an email tomorrow with a link to the recording of this presentation as well as a survey. To view upcoming webinars as well as previous recordings, please visit our website at colorado.edu/business/alumni. We hope that you will join us for our next webinar, which is this Thursday, as mechanical engineering alumnus and current industry and certificate director for system design and management at MIT, Ben Linville Engler, presents on mobilizing a statewide manufacturing response to COVID-19. In the meantime, have a great rest of your day. Thank you for your time, and go Buffs.